This is a special Wednesday edition of PFTPM, recorded right after the conclusion of PFT Live, which means I'm hungry, I want breakfast, so I won't be talking for all that long. But this is something that I need to delve into. It relates to the Jon Gruden lawsuit against the NFL and Commissioner Roger Goodell for the leaking of the emails that caused Gruden to exit as head coach of the Raiders 5 or 6 weeks into the 2021 NFL season. I don't have any notes. I do have a rough idea in my mind as to how this should unfold, so let's just see how it goes, shall we? And I'll start with a basic background. Jon Gruden, as we know, had coached the Buccaneers to a Super Bowl win. Then when he was fired by Tampa Bay, he became the voice of Monday Night Football, along with Mike Tirico in the booth doing the games, catbird seat for when and where he would return to the NFL. He eventually did as head coach of the Raiders. And then, as a result of the investigation into allegations of workplace misconduct within the Washington franchise, a treasure trove of emails were harvested as part of the investigation, some 650,000 documents. Those were supposedly confidential, supposedly secret, and they included among them some highly inappropriate emails sent by Gruden to former Washington GM and then president Bruce Allen while Gruden was working for ESPN. Wasn't employed by the league at the time, wasn't employed by any of the teams, was employed by a broadcast partner, sent those emails. They were inappropriate for a variety of ways, and they were part of this collection of confidential emails that were simply part of this investigation. We wouldn't have known about any of the emails if there hadn't been the investigation conducted by initially Beth Wilkinson and then Mary Jo White into misbehavior within the Washington football franchise. So, despite the fact that the documents were confidential, someone harvested a small group of those emails, the ones involving Jon Gruden, the ones sent by Jon Gruden, removed them from the stack, initially leaked some of them to the Wall Street Journal on a Friday during football season. It created an issue. There were some highly inappropriate things said about DeMaurice Smith, the former NFLPA executive director. That created a bit of a buzz. It carried into the weekend. The Raiders played a game. On the back end of it, it felt like, as things often do, it was dying down. Then came, on Monday, more emails, this time leaked to the New York Times. By Monday night, Gruden had resigned under pressure and he was out. It happened that fast when the second batch came, because I think the unspoken message was, they're going to keep coming. Mark Davis didn't want to fire Jon Gruden. Jon Gruden didn't want to step down. Those emails were going to keep coming until Gruden left. So, in the aftermath of that, Gruden filed his lawsuit. Because if we set aside the inappropriate nature of the emails, and that's hard to do. I know it's hard to do. You can argue very persuasively he got what he deserved. Even if it happened in a way it shouldn't have happened, he got what he deserved. These things came to light in a way that they probably shouldn't have, but they came to light. And they should have come to light, and he got what he deserved. It's very easy to say that. That said, two wrongs don't make a right. I heard that somewhere. These never should have come to light. They shouldn't have been weaponized. My concern was, God, how many other people are caught up in this long list of emails, and we're going to have selective leaks here or there. Remember, there was a moment where Jeff Pash, the outgoing NFL general counsel, got caught up in emails he had sent with Bruce Allen. So are they just going to pick and choose who they're going to take down with these? This is a confidential collection of emails that is being used selectively to target people. It's a hell of a thing for the NFL to have its finger on the button of. So Gruden filed a lawsuit within a month or so after leaving his job as coach of the Raiders, November of 2021, against the league and the commissioner for tortious interference, intentional interference. Tortious is the fancy lawyer word, with his business relationships both now and in the future. And the argument's pretty simple. You, in a way that you shouldn't have, you weaponized these emails to take me out. You saw an opportunity to take me out, and you took me out. You forced my employer to force me out with improper means. Before we even get to the merits of the case, and we've never gotten to the merits of the case, before we get there, the NFL did what it always does. The first line of defense in all these cases is if they can make the plausible, straight-faced argument, the case should go to arbitration. And we've talked about this before, but here's the basic difference. And this is true for most American business, if not all American business. You'd rather go to arbitration than go to court for a couple of important reasons. First, if you do it in arbitration, you can keep it all secret. Nobody knows. There's no court filings. There's no open proceedings. Nobody knows what was said. Ideally, look at what happened with the Terry McDonough arbitration against the Cardinals. He got fined $25,000 for sending me emails I didn't even open because it violated the gag order that was put in place for that arbitration. Keep it all secret. Nobody knows about it. Nobody finds out any of the allegations or any of the facts relating to the things you did that maybe you shouldn't have done. Secondly, it also circumvents the jury system. So instead of having a group of regular people, and in most states, a civil jury will be 6, some states more. It's never 12. It's rarely 12. But instead of being accountable to individuals who might be more inclined to identify with the person who thinks they got screwed than the company that did the screwing, instead of that, you have a lawyer, retired judge. You have one person who isn't going to be susceptible to the basic sympathies of a case and is going to keep it within the letter of the law. The outcome is going to be less likely to blow the roof off of the balance sheets, the McDonough case. Ultimately, McDonough won $3 million. Well, if that case had gone to a jury, add a zero and maybe double it is what the verdict quite well would have been. You're going to get a greater likelihood of winning, and you're going to have a smaller verdict if you lose if you can push the case to arbitration. It's one of the reasons why companies will routinely take advantage of any way they can to cram arbitration clauses into contracts. And you'll see them in consumer contracts in fine print on the back side, and there's been tons of litigation over the years as to how far these companies can go in forcing cases out of the open public court system and into these secret rigged kangaroo courts. And it's especially a secret rigged kangaroo court when it comes to the NFL, because most companies will defer arbitration to some outside entity, the American Arbitration Association or groups like that, where there's somebody who's truly disconnected from the process who's making the decision. It's still favorable to the company, but it's not as favorable as saying, like the NFL does, the commissioner will resolve all disputes. The commissioner will be the person who determines whether or not one of the teams that employ and pay him did something wrong. So the secret rigged kangaroo court that is the court of Roger Goodell gets activated whenever the NFL can do it. In Gruden's case, the problem was the arbitration clause in his contract didn't apply because he didn't sue the Raiders. This was a lawsuit against the league and the commissioner. So what the league had to do, the league had to carve out a portion of the NFL Constitution and bylaws that gives the commissioner the exclusive authority to resolve any disputes that relate to conduct detrimental to the league. And they bootstrapped this argument that, well, the detrimental conduct was Gruden sending the emails. Wait, he wasn't employed by the league at the time, so how's that detrimental conduct within the confines of the league? Well, the detrimental conduct is what Gruden is accusing us of doing. So Gruden is accusing the league of detrimental conduct in leaking these emails in a way that's calculated to get him out of his job, and the commissioner has the exclusive jurisdiction to determine whether the detrimental conduct he's accused of engaging in was indeed detrimental conduct. I mean, it makes no sense. And what happened in this case was, at the lower court level, Jon Gruden got a ruling that he can go to open court, that the NFL is not going to be able to enforce this nonsensical, clunky, clumsy arbitration clause from the NFL's constitution and bylaws onto Jon Gruden. It's not going to happen. That was the lower court ruling. It ends up in the Nevada Supreme Court. And look, this case was filed November of 2021. Here we are in May of 2024, still stuck at square one of this litigation on the question of whether or not the case is going to go to open court or be arbitrated. So yesterday, a 3-judge panel, there are 7 justices on the Nevada Supreme Court. The way they do it, 3 of them get assigned the case randomly. 2 said arbitration. 1 said Jon Gruden can go to open court. 2-1. So, and that's how simple it can be. Justice can turn on the opinions and reasoning and conclusions of one person. And there's a saying in the law that bad facts make bad law. And that's true. And what that means is, like in a case like this, Gruden's not a sympathetic figure. You have to set aside a lot of stuff to get to the point where you're ready to give Jon Gruden a crack at the NFL. Beyond the emails, he was the highest paid coach in the NFL at the time. And the NFL made that point over and over again. And that point is even made in the majority opinion about how much money Gruden was making. You don't feel bad. You don't feel sorry for a guy who did something he shouldn't have done and was pretty damn well compensated while he was working for the Raiders. It makes it harder for that guy to get a fair shake. And that's just the way it is. I've got no sympathies for Gruden, and I think at a certain level he did get what he deserved. But that doesn't make what the NFL did right. And my bias, and I'll admit it, I want to know what happened. So the only way I find out what happened, the only way we find out what happened, is if the case goes to open court, because they're going to try, and it's not over yet. I'll get to that in a second. They're going to try to force this case into arbitration. We'll never know what happened. And you won't win, and we all lose because we don't get the benefit of finding out what the truth was. Now, it's not over in the Nevada courts yet. 2-1 on a 3-judge panel. The way I understand the Nevada rules of appellate procedure, first he has to file a petition for rehearing. Basically, can I get a do-over? Can we do this again? Can we take another look at this? I think you might have gotten it wrong. If that petition for rehearing is denied, then he has the ability to seek a hearing in front of all 7 justices. And hey, when you go 33%, when you convince one judge out of a 3-judge panel, let me see what all 7 will do. Let's see. Let's see if we can get the full court to look at this, and let's see if I can get a 4-3 win. And the stakes are so high. There are certain decisions that are preliminary in nature to a case, but they are so critical to how the case is going to play out. And this is as critical as it gets. Am I going to be in open court and have a fair shake at getting to the truth and getting justice, or am I going to get sent to the secret rigged kangaroo court of the National Football League? So Gruden, I believe, will file the petition for rehearing, and if and when that's denied, file a petition for consideration by the full court. The fancy Latin phrase is en banc, which makes me feel very sophisticated to say that, which is why I said it. Then, if he loses there, or if he wins, either way, losing party is going to take it to the U.S. Supreme Court. There's no guarantee that the U.S. Supreme Court is going to do anything with it, but it will slow the process down. That's exactly what happened with the St. Louis litigation against the NFL. That case got caught up in the gears of the court system for 5 years because the NFL ultimately lost in the Supreme Court of Missouri and took the case to the U.S. Supreme Court. The U.S. Supreme Court eventually denied the petition to take up the full case, but that takes time. It interjects more expense and delay into the process, and we have to wait longer and longer to find out, even if we're going to ever get a chance to find out what the truth was. So that's how it's going to play out from here. Petition for rehearing, petition for en banc review, win or lose, and I don't know that Gruden's going to take it all the way to the U.S. Supreme Court. And if I was Gruden, I wouldn't, because you're probably going to lose in the U.S. Supreme Court. Now, maybe he'll try his luck. Maybe he doesn't understand. And look, I want to make a political observation without being political. One of the basic realities when you practice law, and I did for 19 years, and I'm not saying that because I'm bragging about it. It just gives me the ability to comment on this with some, direct experience. Judges that end up in their position, especially at the federal level. At the federal level, they're all appointed. So that's one of the most understated powers of a president. Every vacancy at every level of the federal court system, from the district courts to the appellate courts to the U.S. Supreme Court, every judge is appointed by the president who is in office at the time. And they have to be confirmed by the Senate, but, typically that's what happens. Sometimes it gets bogged down, but that's how the justice sausage gets made at the federal government level. So, general rule of thumb as it applies to employment cases, and those are the cases I handled almost exclusively for more than half of my career. About 2/3 to 3/4 of my career. I'll say 3/4 of my legal career was employment cases. When you're the company, you want a judge who is along the Republican side of thinking. When you're the individual, you want somebody who is more along the Democratic lines. And you see it play out. Time after time, case after case, you see it play out. The judge with the conservative background is more inclined to give a pro-business ruling. The judge with the Democrat background is more inclined to give a pro-individual ruling. That's just how it is. That is a fact. That's not a political observation. It is a fact. That's how it works. And in this case, based on everything I've heard about Jon Gruden, he leans pretty hard to the right. And hey, you're going to get what you paid for, Jon, if you go to the U.S. Supreme Court, because you're going to lose 6-3 at best before the Supreme Court. You're going to lose. They're going to find in favor of the company. They're going to find in favor of the business interest, because the precedents that come from this case get applied to future cases. It's not about who do I like or not like in this case. It's about what legal reasoning here will become the law of the land. So they're either going to not take up the case at all, or if they take it up, they're going to find in favor of the National Football League. Because as of right now, 6-3 is the best you're going to do if you're an individual trying to get justice through the court system, through the federal court system. That's how it works. Now, in Nevada, I get the impression they do nonpartisan judicial elections, and I don't know enough about the makeup of the court to know who leans right or who leans left. I have a feeling if I did the full deep dive into the background of the three judges who ruled on the Gruden case, 2 probably lean right and 1 probably leans left, because that's what happens here. The reasoning from that case becomes the law of the land in Nevada. So, look, maybe he can win through rehearing or through a petition for a full court hearing. But the Hail Mary pass for the NFL will be to take it to the U.S. Supreme Court and try to get them to take it up and overturn it and give the NFL what would be a pretty strong weapon to try to force as many cases as possible into arbitration, into the secret rig kangaroo court. So there's a lot riding on this, but it's probably going to take another 2 or 3 years for it all to play out, maybe longer. I mean, think about it. You got the petition for rehearing. What do they do with that? You got the petition for en banc review. What do they do with that? Takes time. A month here, a month there. It sits. You finally have a hearing. You finally get a ruling. They had the hearing on this at least 3 or 4 months ago. I think it was finally in January where they had the hearing on it. So it takes time. And we're already 2.5 years in to this process. Okay, so here's the other reason why people should care about it. Because this is more than just, was Jon Gruden in some way victimized by the National Football League? And remember, this is all happening in an age of legalized wagering. So, before the 2021 season began, and during the 21 season, there's wagers you can make on what the Raiders will do. How many wins? The over-under. Do you bet the over? Do you bet the under? Based upon whatever the Vegas win total was for 2021 entering the season, or adjusted on the fly as the season unfolds. Chances of winning the division, either before the season or once the season begins. Are you betting on the Raiders to win the division? Or are you betting on another team to win the division? Are you betting on the Raiders to win the Super Bowl? Do you have one of those tickets that pays, pretty good money if the Raiders get to the Super Bowl and win it? Well, by taking out the head coach of the Raiders, regardless of the reason, regardless of whether or not he deserved it, okay, it was reported at the time that the NFL was aware of those emails in June of 2021. They could have acted on Gruden then and given the Raiders a chance to hire a new coach to start the season from scratch. And everybody knows Gruden's out before they ever kick a football. We all know Gruden's out. Or they could have waited until the season was over to act on pushing Gruden out. Whoever did this did it 5 or 6 weeks into the 2021 season. Necessarily undermining, what's that phrase the NFL always likes to wrap itself in like it's the flag? Integrity of the game. We always must protect the integrity of the game. How are you protecting the integrity of the game when someone, and it's a small universe of people that had access to these records, when someone selectively leaks a small number of documents from a 650,000 email treasure trove with a specific design of taking out Jon Gruden, and he gets taken out, and the Raiders are thrown into turmoil 5 or 6 weeks into the season. They still made it to the playoffs and almost beat the Bengals, but for, questionable call. Remember that phantom whistle? And then they had the ball driving to tie the game late. If Jon Gruden, and I know that it's all hypothetical, but if Jon Gruden doesn't get fired or forced to resign, what do the Raiders do that year? We didn't get to find out because somebody undermined the integrity of the season by forcing Jon Gruden out. That's the big picture that we all should be concerned about. That's the dirty little secret that has gotten lost in the shuffle here. If I'm Congress and I'm paying attention to the NFL and trying to figure out whether and to what extent I should regulate it, I look at that example and I say, man, they talk about integrity of the game. Somebody took a big old dump on the integrity of the Raiders season in 2021 by specifically choosing that time to send the emails to the Wall Street Journal, to send the emails when the Friday batch didn't result in the desired outcome, to send more emails on Monday, to have Jon Gruden tap out on a Monday night, and the Raiders' season to be thrown into complete and total chaos. They messed with the integrity of the season. So I want to know who did it. I want to know what the commissioner knew and when he knew it. I want to know what his role, if any, was in either giving the green light, giving the nod, or affirmatively being the one to send them. Gruden thinks it was Goodell. Some people think it was Daniel Snyder, the former Commanders owner. We don't know, but there weren't many people that had them. And if the case plays out in open court, we will find out who ordered the code red. We will find out who sent the emails to the Wall Street Journal and the New York Times. We'll know. And then the chips may fall where they will. At one point last year, Gruden said he wants to burn it down. And let me tell you something. If he gets a chance to force this into open court and litigate it all the way through to a verdict, maybe he will burn some people down. If the commissioner isn't already retired by then, maybe he will be, depending upon how that all plays out. Unless it ends up in arbitration. Secret, rigged, kangaroo court, where none of this stuff is ever coming out. None of this stuff. There's no way they're going all the way down the rabbit hole to find out what Jon Gruden knew. There'll be some preliminary argument made by the NFL that regardless of what happened with the emails being released, the conduct of Jon Gruden supersedes all of it and it renders it moot. There'll be some other argument. There'll be something. They'll come up with some legal argument that the arbitrator who is assigned to handle the case will say, yes, you win, that keeps this from ever getting to the point where we find out who ordered the code red. That is the tragedy of this case if it ends up in arbitration. And hopefully, as this process goes forward in Nevada, I don't know if there were, and they call them amicus briefs, friend of the court, where there are others whose interests are directly or indirectly affected by this case, chime in. News organizations should chime in. Others who have an interest in the integrity of wagering and the integrity of football games should consider chiming in, because we never figure out who undermined the integrity of the 21 season without knowing who leaked those emails with the clear intent to take out Jon Gruden. So that's where it all stands. I could keep talking, but I'm really hungry. I'm surprised you can't hear my stomach growling. So I am going to say for now, have a great day. Thanks for listening if you made it this far. I know this stuff isn't like the normal football stuff, but this is going to sound horribly immodest, but you're not going to get this anywhere else. There's no one else that is going to take 20 minutes to break this down, to have the ability to do it, the understanding on how to do it, and the desire to sit here for 20 minutes, deprived of food and coffee, more importantly coffee, to tell you how this all works. So if you wanted to know, if you were looking, you found the right place, and you made it to the end. You get a cookie if you have any cookies available. If you don't, I'll send you some. I won't. It's just something to say. That's it for now. See you Thursday morning for an all-new edition of PFT Live. Check us out around the clock at ProFootballTalk.com. Thanks as always for your support, and we will see you again very soon. Hi, it's Mike Florio. Thanks for watching PFT on YouTube. Hit subscribe for the latest news and analysis from Pro Football Talk.